Our educational speaker has spent her first 13 years in the workforce as a U.S. Air Force officer. She then completed a law degree and began working for the Washington State Attorney General's office, prosecuting child abuse and neglect cases. In January of 2008, she was appointed to be the executive director of the Washington State Executive Ethics Board. Since August of 2014, she has been the executive director for the Washington State Medical Commission that licenses, regulates, and disciplines approximately 34,000 allopathic physicians and physician assistants who care for patients in Washington. In 2019, her commission won the Administrators in Medicine Best of Boards Award. She is currently a staff fellow on the Federation of State Medical Boards Board of Directors. And I'm very pleased to welcome as a first-time presenter to the FCLB, Melanie DeLeon. Melanie, we're going to make you co-host, and then you can share your slide deck with us.
Okay, thank you very much. All right. Okay, I'm assuming everybody can see my first slide. Okay, great. Well, thank you for allowing me this opportunity to speak with you today. I'm going to be covering an issue that has been in the media and in our minds a lot lately. But a little bit about me. Again, you heard my bio. I'm the executive director of the Washington State Medical Commission. We are an independent regulator of allopathic physician and physician assistants in Washington State. In Washington, the osteopathic physicians are regulated by a separate board. We have about 34 licensees, and we issue about 2,700 new licenses a year. Today, again, I want to share with you a new way that we are processing and investigating sexual misconduct complaints against our licensees, and a little background as to what prompted us to do that. We had some issues and we needed to change our process, so I'll kind of walk you through that. And then I'm also going to touch briefly on sexual misconduct in general, and because it's become a very high-profile issue today. So here's a little bit more about my commission. And my slide is not moving. Yay. There we go. So we have 21 governor-appointed members. 13 of them are physicians. Our physicians represent, 10 of them represent our federal congressional districts, and then we have 3 at-large physicians. We have 2 physician assistants and 6 public members. We're the 3rd largest medical board in the nation, which might be surprising to you. We're behind New York and Maryland. For some reason, Maryland's got a huge board. Commissioners are appointed to a 4-year term, and they can be reappointed for another 4-year term. They can also apply to be a pro tem member for 3 one-year terms, or 4 one-year terms. So all in all, they can be part of the board for about 12 years. We process about 1,500 complaints annually, and we investigate about half of those. My legal unit processes about 80 legal actions annually, and we have an average of about 190 cases in compliance at any given year. So what started this whole thing with us regarding sexual misconduct? In 2006, the Seattle Times, which is our major newspaper here in the Northwest, published a series of stories that were called License to Harm. And this reporter and collection of reports and stories were about case after case of sexual abuse and misconduct that was perpetrated by medical providers and many different provider groups. It wasn't just one particular group. Now, while the articles focused on the actions of mental health registered counselors, it also highlighted the actions of physicians, chiropractors, and others, and basically called out our Department of Health's dereliction of investigating and doing anything with these matters. The case that first got the reporter's attention was about a psychologist who'd had sex with a female patient. The regulators from the Department of Health concluded that the psychologist could continue to treat women, but only those older than 50. So you're wondering, I guess the people he had sex with were under 50 and the regulators thought if you were over 50, you were out of the pool. I don't know, but that's what they decided. And absurd as that was, at the time, it wasn't unusual. The reporter stated that sexual misconduct in healthcare is not new, but he was struck by how the state dealt with them. He said, sexual misconduct is treated as a medical error and routinely dismissed and forgiven. And until this article came out, sexual misconduct cases were actually kind of pushed out of the way. And I don't really blame the commissions or boards for doing that, because it's not something that commissioners are really trained to review. They look for standard of care issues or those kinds of things, and sexual misconduct issues was just really foreign to them. So after this particular article came out, the Department of Health gathered all the boards and commissions and all of the other professions that don't have a board and commission, and they did a lot of rulemaking. And they initiated rulemaking to basically define and put some teeth into their sexual misconduct rules. And so they had to define what sexual misconduct was. And so they said, well, sexual misconduct is not only, you know, your what you think it would be, having sex with the patient, those kinds of things, but it included a laundry list of other things that they would consider sexual misconduct. It included kissing in a romantic or sexual manner, not allowing the patient the privacy to gown or dress in privacy, soliciting a date with the patient, engaging in conversation regarding the sexual history, preference, or fantasies of the physician. And here's one that people don't think about, but it's sexual misconduct in our state now under this rule if a physician examines a patient's genitals without wearing gloves. So that is now a sexual misconduct under the rule. So they said that a physician should not engage in sexual misconduct as defined by the rule with a current patient or a key third party. So then the rule had to go on to define what a current patient was. And under the rule, the determination of when a person is a patient is made on a case-by-case basis with consideration given to a number of factors, including the nature, extent, and context of the professional relationship between the physician and the person. And the fact that the person is not actively receiving treatment or professional services is not the sole determining factor. They also had to define what a key third party was. And in our rule, a key third party means a person with a close personal relationship with the patient. So it could be the patient's spouse, it could be their sibling, it could be their child, their parent, their guardian, or their proxy. So not only can a physician not have any kind of sexual relations or any kind of defined misconduct with the patient, but also with the key third party. And lastly, they talked about former patients, and that gets a little murkier actually, but the rules state that a physician can't engage in any kind of conduct with a former patient, like I described previously, if the physician uses or exploits the trust, knowledge, influence, or emotions derived from the professional relationship. And under our rule, it's not a defense that the patient, former patient, or key third party initiated or consented to the conduct, or that the conduct happened outside of a professional setting. So there are two pathways in Washington State when we receive a complaint regarding sexual misconduct with against a licensee. So if the complaint has a clinical component to it, in other words, the misconduct happened during an examination or other kind of a clinical component, then the commission, my commission, retains that case. We investigate it and we take disciplinary action if appropriate against the licensee. If the complaint does not have a clinical component to it, in other words, the physician and the patient are having sexual relationships outside of a clinical setting, they're meeting in a hotel or whatever, then we are required to forward that complaint to the secretary's office, and the department investigators do the investigation and they take appropriate action on that particular case. So again, it can go two ways. I will tell you that the majority of the cases that we get, most of the complaints actually are about something that happened during an examination. And so we usually retain most of the complaints that are filed with us. Several times a year, we will get those odd complaints. Usually it's from a person who's had a relationship with a physician that went south, and then they file a complaint regarding that physician. And at some point in time, maybe the physician prescribed pain pills or something to that person, so that makes them a patient. So we do get those occasionally, but mostly our complaints have to do with something that happened during an investigation. Now, as you can see here, between 2008 and 2019, actually it's 20, I can't see that part, we've had a dramatic increase in the number of complaints filed regarding sexual misconduct. I will say that it's kind of peaked after we had the #MeToo movement. We had a lot of complaints filed during that time frame, and they've kind of leveled off now. But the information that I think is important for you to see on this particular slide is that the complaints that we've authorized to investigate, the percentage has gone up from 33% in FY 2008 to 85% in 2020. So we are investigating a bigger percentage of the complaints that we're receiving. Now, while my commission doesn't investigate crimes per se, we do work alongside law enforcement agencies when they investigate practitioners for actions that may be considered as unprofessional conduct under our statutes, especially allegations of sexual misconduct, assault, or rape. We have several cases now where we are relying on law enforcement to provide us with some information regarding sexual assault and rape allegations. And for some context, I wanted to tell you that crime generates substantial cost to our nation at an individual, community, and at the federal level. And I wanted to kind of go over that today just to give you some context. Based on nationwide data, drunk driving costs our nation about $61 billion annually, murder 71, assault 93 billion. But as you can see here, that sexual misconduct and assault cost more than any other type of crime for our nation. And you might be saying, well, what's included in that cost? I have no idea. So I researched this, and in 2017, the American Journal of Preventive Medicine released a research on the cost of rape based on a study by the Centers for Disease Control and Prevention, which was entitled "A Lifetime Economic Burden of Rape Among U.S. Adults." The study took into account the criminal justice costs, the property damage or loss, lost work productivity, and the short and long-term physical and mental health treatment for victims. And they calculated that the lifetime cost for a victim was about $103,000. So who are the victims? Over 25 million Americans will experience rape during their lifetime, and a vast majority of those are women. This overwhelming majority holds true for all other nations as well. According to the Rape, Abuse, and Incest Network, 7 out of 10 sexual assaults are committed by someone that is known to the victim. And there's been a long standing agreement within the medical profession that sexual conduct with the patient is unethical. Yet studies estimate that between 5 and 10% of all physicians have had some sort of sexual contact with the patient. Physicians from all specialties and backgrounds are involved. Nearly all the violators are males, and most of the victims are females. However, it's also felt that a true picture of this problem is underreported because reporting systems by states, and mine is included in that, we don't categorize complaints or actions by type or specialty. So the data is very limited. For example, we aggregate all types of data, but we don't slice it by specialty. So I don't know how many OBGYNs are doing one thing and how many orthopedic surgeons are doing another. They're just all physicians in my database. It might be easier for your group to do that, but in mine, I have so many different specialties that it's hard to slice the data that thinly. And we are working with a very old database. Our database has been around since 2008. You can't really update it anymore. So we're trying to find better ways to get that data. Now, we've seen an increase in media interest on sexual assault or misconduct cases across all professions, and here's some examples of those. Here's a headline that came out on September 9th, just this past September. This indictment alleged that a 62-year-old physician sexually abusing dozens of his OBGYN patients, including minors, over a span of 19 years. This was done in his New York medical offices and an affiliated hospital. The federal officials charged him with 6 counts of enticing and inducing individuals to travel interstate to engage in illegal sexual activity, and each of those counts carries a maximum sentence of 20 years in prison. From 1993 through 2012, this physician allegedly used examinations to cover up his engagement in sexual abuse because he masked it as legitimate medical care. It kind of makes you think of the Larry Nassar case, but this is a completely different case. Officials noted that the doctor would either send the nurses or medical assistants out of the exam rooms or intentionally go into the exam rooms and not tell his medical assistant so that he could be alone with his patients. Not a day later came this particular headline. This is a case that began in 2019 when a patient told police that she'd been abused over the previous 5 years while receiving psychiatric treatment from this psychiatrist for an eating disorder and prior child sexual trauma. The sexual contact first started in his office and then it moved to his home. At sentencing, the woman read a victim impact statement and revealed that she said, "I feel like I lost myself, my worth, my dignity, lost, gone. I don't get that back. A judge's sentence doesn't get that back, not for me, not ever." She said that this psychiatrist would adjust her medication anytime she felt depressed in order to, quote, "make me feel happy again." She said, "Now I see I was really an over-medicated sexual puppet." So in August of 2020, the Medical Journal of Australia published a landmark study entitled Sexual Misconduct by Health Professionals in Australia, 2011 through 2016, a retrospective analysis of notifications to health regulators. And the reason that this was a landmark study is because it studied all of the health professions, not just one particular one like doctors or chiropractors. It studied all of them. And they have 15 defined health professions. And the purpose of this study was to assess the numbers of notifications to health regulators alleging sexual misconduct by healthcare profession. And so here are some of the findings that they made. Gender: 88% of the subjects of the complaints were men, 12% were women. Of the 12% of the women, 62% of them, if you can follow that math, of the complaints against the women were about having sexual relationships as opposed to sexual assaults or misconduct. 72% of the practitioners receiving complaints were over the age of 46. Less than 10% of the subjects were under the age of 36. So this seems to be an older person's issue. Now, while physicians, psychologists, chiropractors, and osteopaths comprise 22% of the registered practitioners in Australia, 75% of the sexual misconduct complaints involve these professions. And although nurses and midwives comprise 60% of practitioners in Australia, less than 20% were subjects of sexual misconduct notifications. So you have to kind of ask yourself, are they doing something right? I don't know. So if the hashtag #MeToo movement has shown us anything, it's that coming forward is fraught with potential landmines, whether reporting an act of sexual violence or workplace sexual harassment. So how do you combat an issue when the victims don't want to talk about it? And you have to ask yourself, why won't the victims come forward? And the answer is that most victims are kind of blamed for what happened to them. And this is different than most other allegations that victims make. You know, they will say, well, if you didn't wear that short skirt, or if you didn't drink so much, or if you didn't go to that party, this wouldn't have happened to you. They're blamed for the actions that are taken by another human being who is also making a decision to grope, assault, or rape. Many women cite a major barrier to reporting their assault, be it to the police or to their family or friends, is their credibility. Will people actually believe them when they say what happened to them? Or worse, will the people blame them for the assault? Regulators, regulatory boards, we need to be part of the solution and not the problem, because we say that protecting the public is our mission. And so we have to make sure that we are helping them do that. So these movements have society finally acknowledging that perhaps men don't understand and cannot really represent the lived experiences of women. We need to develop and implement ways to reduce barriers for victims of sexual misconduct or assault at the hands of one of our licensees to report that misconduct to us. And we need to make sure that we do something to believe them. Again, I'm hearkening back to Australia, and I'm going to bring them up a couple more times because they really seem to have been focusing on this issue lately. And the Medical Board of Australia recently established a national committee for responding to sexual misconduct notifications, and they have trained investigators that have specialized expertise. So they've kind of gone above and beyond what most other medical boards are doing. And I wanted to kind of give that to you. Again, there's a lot of work being done by Australia regarding sexual misconduct. So we talked a little bit, or I talked a little bit about the media scrutiny. And this media scrutiny actually became up close and personal to me when the Atlantic Journal-Constitution a couple of years ago published a series of articles regarding doctors and sex abuse that highlighted the national investigation into how state medical boards actually dealt with these types of issues. And in their series, which is entitled License to Betray, the Atlantic found a broken system that forgave sexually abusive doctors in every state, and ours was included. The journal went on to rate each state and how they protected patients from sexually abusive doctors based on 5 factors. And let me explain to you what those were. Transparency. Was complete and accurate information on physician discipline provided to help patients protect themselves? We didn't really grade well in that particular section because we really didn't tell people proactively about any kind of action taken against a doctor for sexual misconduct. But we have since changed that, and I'll talk about that a little bit later. Duty to report. Our colleagues and institutions that are aware of potential physician misconduct required to notify regulators. That is in our statutes and our rules, so we do have that. Board composition. Are consumer members included to balance the physician's tendency to identify with their colleagues? We have 6 public members, so clearly almost 1/3 of our board are public members, but there are other boards and commissions that have a very small public member presence, and so that was one of the things that they zeroed in on. Criminal acts. Are medical regulators and law enforcement made aware of doctors' criminal conduct? We find out about criminal conduct in the sexual manner usually from law enforcement, but we have very few cases that come that way for us. Other criminal conduct, we really don't seem to get a lot of information on. And discipline laws. Do laws strengthen oversight and discipline of problem physicians? And we have physicians that we've taken multiple actions against, not so much with sexual misconduct, but for standard of care, because one of the requirements for us, and I don't know if it's true across the nation, is that we have to try to remediate and improve the physician. And if there's a way to do that, then, you know, they retain their license because they do have a property interest in that license. So we try really hard to fix whatever issue it is so that they can continue to practice. So through this research, the journal found that while the medical profession condemns sexual abuse by doctors, it kind of resists solutions. Now, Washington rated 7th best in the nation under their study, and so that was good. But in gathering the information to provide the journal, because they did interview us and gather information from each state, I actually found some very disturbing realities about how we had been dealing with sexual misconduct cases and allegations against physicians. And most of the commissioners regarding cases of misconduct at that time called them boundary issues, which is a term I actually don't like, so that's kind of my deal. But also many of the commissioners repeatedly said that it kind of boiled down to a he said, she said issue, and those issues were very difficult to prove. So again, some of our laws have changed, and I want to talk a little bit about those because in July of 2016, one of our laws changed, and it required that all of our investigators who were going to do any kind of investigation into sexual misconduct, they had to take a 2-day training that was regarding, it's called trauma-informed sexual assault victim training, and they had to do it for them to actually investigate any cases regarding sexual misconduct. And this training was to minimize the impact on the victim's trauma. So my investigators went to this training, and they said it changed their entire perspective on sexual assault and sexual assault victims. But the issue is that no matter how good my investigators are at interviewing victims and writing up their findings, if the commissioners who ultimately present these cases to a panel of commissioners to determine whether or not to take disciplinary action, if they don't understand victimology or the way trauma impacts a victim, they're not going to be able to provide clear and convincing rationale for taking any kind of disciplinary action. So I researched the training that our investigators took and decided, would it be good for our commissioners to also take that particular training? And I found that yes, although the commissioners couldn't do a 2-day training, we were able to provide a 1-day trauma-informed training for them, and so they could do that, as well as our staff attorneys, so everybody would have the same training. So what is trauma-informed sexual assault investigation training? It basically provides information on the neurobiological impact of trauma, the influence of societal myths and stereotypes, understanding perpetrator behavior, and conducting effective investigations. This training helped us understand how specific experiences impact victim trauma, their memory, their reactions and behavior, and how interpretation of this behavior impacts sexual assault investigations. It explained how key decisions made by law enforcement and other investigators impact the progression of a sexual assault investigation, and how the disclosure by the victim often occurs in pieces over time. Lastly, it helps identify strengths for working with victims to facilitate trust and communication. Specifically, the training shows how trauma physically changes the brain and how to focus the investigation on the respondent's behavior and not on the victim. So I've been talking a lot about trauma, and experts have discovered that during moments of extreme stress, humans can undergo what they call atonic immobility, which is a paralysis that can prevent them from moving, screaming, or fighting back. You've heard of stories from victims that said they were frozen, that there wasn't anything they can do, and this is basically what is described as tonic immobility. A study published in Sweden reported that of nearly 300 women who had visited a rape clinic, 70% experienced significant tonic immobility, but 48% met the criteria for extreme tonic immobility. And people often assume and expect that we'll be able to recollect major events in our lives with clear and unwavering accuracy. And that's kind of a determination of truth of what happened. Consistency and recall is always something that we use to kind of judge a witness's credibility. You know, they'll say, well, your story was different last time you told it. And then people will think, well, maybe they're lying because they keep saying and changing their story a wee bit. However, traumatic events such as sexual assaults are encoded differently and than more routine everyday experiences in life. We're not tape recorders. Our memories are fallible and have gaps and inconsistency, especially when remembering a traumatic event. As a result, we recall and narrate traumatic events differently than routine events. The belief is that inconsistent statements mean the victim is lying has created a focus on techniques that focus on lie detection. These approaches further stress the victim and often inhibit what memory the victim is able to recall. It's simply not realistic or rational to expect a victim of a sexual assault to recall all aspects of their traumatic experience in detailed accuracy from start to finish. A better understanding of how the brain responds to trauma has shifted how the medical commission, my commission now, handles cases of sexual misconduct. So in May, this past May, the Federation of State Medical Boards adopted an updated policy regarding physician sexual misconduct. And the first sentence reads, "The relationship between a physician and a patient is inherently imbalanced." The Federation acknowledged the importance of environment and culture from medical school to practice for a physician. The National Academies of Science report that organizational culture plays a primary role in enabling sexual harassment, which can lead to other issues, including sexual misconduct and assault. The American Medical Association's Council on Ethical and Judicial Affairs adopted a report entitled "Sexual Misconduct in the Practice of Medicine," condemning sexual relations between physicians and current patients. The report also raised serious questions about the ethics of romantic relationship with former patients. Further, the report held that sexual or romantic interactions between physicians and patients detracted from the goals of the physician-patient relationship, exploited the vulnerability of the patient, obscured the physician's objective judgment concerning the patient's health care, and ultimately may be detrimental to the patient's well-being. You can recall several slides ago when I was talking about the psychiatrist and how the patient got medications from him when she felt depressed, and she said that she felt like a medicated sexual puppet because the doctor was prescribing based on his wants and needs as opposed to the patient's wants and needs. So these ethical concerns also exist if the patient consents to the relationship or terminates the doctor-patient relationship to enter into a sexual relationship with a doctor. The doctor must be able to trust, or the patient, must be able to trust that their physician will work only for the patient's welfare and not the needs of the physician. So now I'm getting to the part where we've actually changed the way we process our sexual misconduct complaints. And what I say is we got SMART, and SMART stands for Sexual Misconduct Analysis and Review Team. So that's our acronym. We call them SMART teams. And we established this team and developed a whole new procedure for processing cases regarding sexual misconduct with our licensees. So we have 2 commissioners on each SMART team. So now every time we get a complaint regarding sexual misconduct, it's assigned to 2 different commission members. One is a clinical member and one is a public member. Further, one of those members is a female and one of those is a male. So we have a clinician and a public member, a male and a female. So there's just 2 people. We just have to figure out who's going to be the clinician and who's going to be the public member. And we have sort of our public members are split 50-50 male and female. So that works out well for us. Now, to be part of the SMART team and to actually work on one of these sexual misconduct cases, the commissioners must have completed that one-day trauma-informed sexual assault victim investigation training. So until they do that, they cannot work on a sexual misconduct case. And so now we've got commission members who are trained, they understand the neurobiology of trauma, the impact of trauma on a victim, and how that trauma may be the best evidence in a sexual misconduct case. So now we've changed the conversation within our commission, and protecting the public is our primary job. So we have to stop and determine, you know, victims don't think they're going to be believed. We have to make it so that they know that they're going to be believed and supported when they file a complaint against a physician. We want to make sure that we are not saying, you know, saying this is a he said, she said issue. We need to make sure that they're not blamed for their assault, because for some reason, and we don't understand this ourselves, victims of sexual assault are treated differently than other types of victims, and we don't understand that. And again, to give you some context, I think we've evolved in our conversation at the Medical Commission in Washington. We don't call them boundary issues anymore. We call it sexual assault or misconduct. But I was just speaking a couple of weeks ago to the director, he was the medical director of a physician health program in another state, wasn't the Washington state. And he was calling sexual misconduct sexual indiscretions. And that was something I hadn't heard forever. So I don't understand that conversation. So we are trying to change our paradigm. And, you know, we've all been raised to trust those professions that we go to for help, whether it's doctors or coaches or priests or teachers or Boy Scout leaders. And many victims minimize sexual misconduct because of that trust. You know, you think to yourself, wait, did that just happen to me? Oh no, that can't be what happened. And so we have this perception because we trust the person who we're receiving the care or the information from. And in the doctor-patient relationship, the establishment of clear boundaries is intended to create a safe and predictable place where treatment can unfold. The doctor-patient relationship is made unique by their doctor always carrying the burden for maintaining appropriate boundaries in the service of the patient's healing. The burden stems from the power differential, and it never shifts to the patient. It always stays with the doctor. Again, I get really offended personally. This is my own personal, I'm not speaking for the commission. I get really offended personally when physicians characterize sexual misconduct or assault as a boundary issue. And there was one case that really brought this to a head for me. And when I was doing my research for the Atlantic Journal Constitution's article several years ago, I came up on this case. And let me tell you what it was about a little bit. It was about an anesthesiologist, and he self-reported during treatment for his own sexual addiction that over a 12-year period, he had, after putting his female patients under general anesthesia, fondled their breasts. He did this multiple times, at least 15 times that he documented, and his actions were considered a boundary issue. I thought that was a real stretch of what a boundary issue would be. That's sexual assault in my mind. Now, I will have to tell you, cards on the table, my husband is a police officer, so I may be looking at this issue a little differently than some other folks, but to me, fondling my breasts while I'm out cold under anesthesia is not a boundary issue, it's sexual assault. So our role as regulators is to protect the public. So the perception of and the focus of what your organization puts on addressing or how you address sexual misconduct complaints is actually very pivotal to the public. Okay, so I am going to ask you a couple of questions now. There are two case studies that I want to talk about, and the question will be at the end, would you authorize an investigation? And then I will tell you what we did. So you're part of a panel that reviews complaints against physicians. Your job is to determine if the report or complaint should be authorized for an investigation. Here's the fact pattern. You receive a report from a 23-year-old female with a history of drug abuse and overdose-related hospital stays. She has recently been told by her doctor that he can no longer treat her. She claims he refused to fill her opioid prescriptions unless she had sex with him. Would you authorize an investigation? Well, that seems to be super easy for y'all. Oh, we've got some no's. So 93% of you say, yes, you should investigate, and 7% say no. So we investigated this, and it went all the way to a hearing. This was in 2012, before we had our SMART teams. Truth be told, there were actually 5 patients. The allegations ranged from unnecessary breast examinations, not allowing the patient to put on a gown before doing a breast or pelvic examination, failure to use gloves during a pelvic examination, and we lost at the hearing. The hearing panel was made up of our own commissioners. They were all men. And they held that the patients, who were all females, did not immediately file police reports, couldn't recite what happened in the exam room the same way each time they were asked. And in one case, the panel cited that because the patient did not tell her husband of the allegations for 2 days, they weren't credible. So I talked about our SMART teams. Now for hearing panels, we also require that one of the hearing panelists be a female, so that we have both male and female folks on that particular hearing panel. So we lost. That nothing happened to the physician, and he went on his merry way. Okay, so I'm going to go to the next slide. I don't know how to get rid of this polling thing. Okay. So can you see my slide, or just the polling thing? Slide? Yes? Okay, so then I'm going to go on to the next slide. Again, you part of the group that is going to authorize or not authorize a particular investigation. So here are the facts of this case. Maybe not. All right. This is about a psychiatrist who filed a complaint alleging sexual misconduct by the primary care provider of one of her patients. So the psychiatrist has the patient, and the patient, she's filing the complaint on behalf of the patient against the primary care provider of that patient. That sounds kind of hinky, but here we go. The patient is seeing the psychiatrist due to a history of sexual abuse starting as a child. The patient stated that the respondent, her primary care provider, has sent her over 1,400 text messages, has stated that they've made sexual comments toward her, kissed her and fondled her breasts. She doesn't have any of the text messages, and the primary care provider has had one prior complaint against them, but nothing to do with sexual misconduct. So the question is, would you authorize an investigation? All right, so we have 84% would, and okay, now it's changing. I'm going to end. 79% would authorize an investigation, and 21% would not. Okay. Question I have for the tech people. Oh, there we go. Sweet. Okay. So we did launch an investigation. In fact, we summarily suspended this gentleman. We did find all of the text messages. When we did the summarily suspension, he actually came back and surrendered his license. We found that in his talking to the patient, he basically said to the patient that and I want to read this so I get it right. The respondent told the patient, and apparently the patient had been sexually traumatized as a child by her grandfather. And the respondent told the patient that her grandfather may have abused her out of love and affection, and that sexual acts between an adult and a child are considered acceptable by some cultures. That's in the stipulation, so we actually put that down. He is no longer practicing medicine in our state. Okay, all right. So again, we've had some changes in our sexual misconduct discipline rates. You'll see here that in FY18, we kind of peaked at 39%, which means that we investigate a complaint, and then do we actually take disciplinary action based on that investigation? And now it's sort of evened out to where we're at about 20% or so. But again, the conversation has changed within my commission regarding sexual misconduct cases. They don't call them boundary issues anymore. They don't talk about it, a he said, she said matter. Now they question whether an action that is taken by a physician, was it inadvertent or was he grooming the patient? For example, lately, we've had a lot of cases about physicians rubbing up against patients. In a couple of cases, the physicians have gotten erections over this, and then they kind of do another rub up, and that's called fraudering, which is not a term I ever heard of before, but now I have heard of it. But they're like, sometimes the physician will say, well, it was an examination of their, I'm a ophthalmologist. I had to look into their eyeballs and I had to get really close. And so my commissioners are now going, was it inadvertent, or were they grooming the patient to see if they were going to get horrified that this happened, or were they going to say, oh, okay, he really didn't mean to do that? So they're really changed the conversation within my commission regarding these cases. Again, so I talked about when we were doing the Atlantic Journal, one of the things that we were not really good at was disclosing to patients actions taken against a physician regarding sexual misconduct. And our law changed in 2019. So in October of that last year, a new law went into effect that requires a physician to disclose that they've had sanctions against them for sexual misconduct issues. And so here's what the law requires. The doctor has to provide a disclosure to the patient who's scheduled for an appointment that they've been sanctioned for sexual misconduct. And they actually have to provide a copy of the order or stipulation that kind of delineates what happened and the sanctions against them to the patient. They have to provide our telephone number and an explanation of how the patient can get in touch with us for more information. They have to provide the patient with a disclosure form to sign, and that signed disclosure form has to be maintained in the patient's file. So we're not the first in the nation to do this law. This law passed, I'm not sure if it's exactly the same, but California passed a law like this a bit before we did. But this came into effect again last October. So now anytime a doctor has been found to have violated our professional act regarding sexual misconduct, they have to jump through all these hoops to make sure that the patients know about it and have recourse. They can either go to the appointment or they can find a different physician. Again, as regulators, it's important that we establish some process, some messaging about sexual misconduct cases that come to your attention. Ideally, we need to be proactive so that no one else goes through the trauma of sexual misconduct or assault at the hands of one of our licensees. And so what messages do you want the public to hear? And I know that other countries, again, are also struggling with this issue. And we've heard from a lot of other countries. I belong to an international regulators group called CLEAR. Some of you may be part of that organization or not. So I actually interact quite a lot with folks from other countries. And I'm going to bring Australia back because they've been doing a lot of work in this area. And one of the things they found is they did a study in 2017 regarding chaperones. And they decided that were chaperones there to protect the patient? And the study found that no, chaperones didn't provide any more protection for a patient than not having a chaperone. And so we no longer, based on that study and discussions within our commission, provide chaperones as a sanction. We gender restrict. So that is something that my commission is now doing. Our SMART training and process has completely changed our commissioner's perspective, and I believe that we're taking bold steps. So the question I ask you is, what are your boards taking, and how are you handling this situation? And here's some perspectives from our commissioners. I'm just going to kind of go through these very quickly. Mr. Malden is now our chair. He really enjoyed the sexual assault training. Dr. Domino is an anesthesiologist. She really, again, found this training very helpful. Dr. Trescott is a family practitioner. She believes that the chaperones are not really a good option, so gender restriction is now the way we go. Dr. Yu is a public member. She enjoyed the SMART training, and as did Mr. Rogers, who's an attorney. He really enjoyed the SMART training. So those are some perspectives of our commissioners.